So in the meantime, I just want to welcome everyone. This is a program of Fair Districts Ohio. I think a lot of you know Fair Districts Ohio. It's a collaboration with the League of Women Voters, Common Cause, ACLU of Ohio, the Council of Churches, the A. Philip Randolph Institute, many, I'm sure I'm forgetting some of our friends and allies. Many of you were part of Fair Districts from the very beginning with your clipboards out in the world, trying to get those signatures and so that we could get on the ballot. And so we are super thrilled and thankful that we have reforms that will help us protect the rights of voters. You know, throughout the year, we're going to continue to look at complicated issues and just think about all the different angles. There's so many different perspectives to bring into map making. And it is just my profound honor to have this star-studded panel. So first off, if you need or would like closed captioning or a live transcript, there is at the bottom of your screen a CC button. You can click that and that will help you. We will have slides that Lisa from the League of Women Voters of Ohio will be advancing for our speakers. We have the hardworking Mia Lewis, Catherine Tercer from Common Cause helping us monitor those questions. You can put those in the Q&A. We would prefer them in the Q&A, but we'll also try to grab them from the chat. And I'm going to go ahead and get started and introduce my dear friend, Brandi, who just always makes work better. So Brandi is the policy director for the Ohio Council of Churches. She's an ordained clergy from the Church of God in Christ. She has her JD from Capital University Law School with a concentration in child and family law, her bachelor's degrees in political science from Morgan State. She's a mother of one son and just an absolutely incredible advocate for Ohioans. And so I'm going to turn it over to Ms. Brandi, our moderator today.
Thank you so much, Jen, and thank you all who have joined us today. I couldn't be more excited to be a part of this coalition. It's just been awesome to work alongside Common Cause and the League and ACLU and everyone that's leading this work in Ohio. Our organization is new to this work, so I'm just thrilled to hear this panel to give us some historical context, to bring us up to date to all the things we want to know about this subject matter. I'd be remiss if I didn't just pause for just a second. You know, there's just so much going on from a race perspective. So I just want everyone to just center themselves, and I'll go ahead and introduce Miss Celina. Thank you for that. Miss Selena Stewart is our first speaker, and I'm just couldn't be more happy to hear from her. She joined the League of Women Voters as the Senior Director of Advocacy and Litigation in April of 2018. In this role, she develops and implements League political strategies and policy positions around election reform and voting rights issues. She oversees prospective litigation for national and state leagues, works closely with League grassroots staff in implementing national agenda, and serves as the lead lobbyist and liaison with Congress and the administration for the League. Prior to joining the League, she was the acting chief operating officer and the director of philanthropy at an election reform nonprofit, where she split her time between managing a small but mighty development team and managing the day-to-day operations of the organization. Celina's experience also includes serving as a litigation consultant to several 100 law firms handling complex merger and acquisition transactions, a legislative aide at the Michigan legislature handling the public interest portfolio for the House tax chair, and as legal counsel to the minority leader at the Georgia House of Representatives. Celina earned her JD from Western Michigan University Law School and her BA in sociology from Spelman College. Way to go, HBCUs, yes. She currently serves on the board of the Bar Association of DC, the Women's Bar Association of DC, the National Association of the Advancement of Colored People, and was an American Bar Foundation Law Practice Fellow. Beyond her professional and social accolades, she's an avid foodie and a wine tasting enthusiast. Join me in welcoming Selena Stewart.
Thank you so much, Brandi. I was listening to you and I was like, who is that girl that they talk? Who is that? So funny to kind of hear your bio you talked about. But yeah, I'm thrilled to join everyone today. So thank you so much to Brandi and all of my fellow panelists, and also the League of Ohio, Common Cause, and all the sponsors for this event tonight, because it's just really a pleasure to be with you all. So I really am just here to talk about voting rights and redistricting and the connection between the two, and try to provide a framework for tonight's discussion. I know that we have many experts on the panel, so I'll just jump right in. Next slide, please. So first, I think it's important to talk about why maps matter. So I think, just as some background, just so if people are not aware, the census, I'm sure everybody here is aware, census happens every 10 years, which basically counts everyone in the country, and that is called, the physical count. And then that number is apportioned across the country to figure out how many people will be in each congressional district. And so from that process, we then start to draw the lines of what districts look like. And so I think it's important to talk about why maps matter, because sometimes it's something that's kind of pie in the sky. We don't always relate it to everyday things that we do, like our streets, our roads, who's running our election boards, who's running our education boards with our school boards with children and such. And so I think it's just important to talk about why maps matter. So the good, let's talk about the good first. So a good map, or good or bad maps, is going to show effectively the racial and linguistic representation across the state. And what that means is, what's the demographic of the state based on race, and also how people identify ethnically and language-wise. The second thing is, it demonstrates the power of communities, many times based on who is a part of the state, who's living in certain communities. Sometimes that allows folks and communities to coalesce or to come together in order to do things like elect their candidate of choice, or make sure that you're pushing for local and state initiatives that forward what your community needs. And then another thing, this is by far not an exhaustive list, just a few things I want to highlight. But the third is, it empowers communities to elect candidates of choice who fight for the issues that matter to them. We know that when certain people are in office, they bring with them, their passions and their drive for particular change. And so if that is not aligned with the community, it causes a disconnect and a lack of accountability in many cases. So the not good. So the not good of maps is it sometimes creates an enforceable record for court. Now, why is that a not good and not a good? Because you don't want to go to court. Litigation is incredibly expensive and timely. And so when you have to use maps in order to create a record for court, or something that's going to be enforceable in court, it sometimes means that you're entering into an arduous process, which I'm sure many of you know. The second is, it demonstrates the political power and will of elected officials. I think it's really important to note that we don't want, or I personally don't want to live in a democracy. The League also pushes for a democracy where people elect our leaders and not leaders choosing who we are, who their voters are. I think that's a really important point when you're drawing maps. And then finally, enables elected officials to ignore certain constituents and prioritize personal interests over community good. And so those are just a few reasons why maps matter, the good and the bad. Next slide, please. So the Voting Rights Act and where the League really stands in this fight. So I thought it might be helpful to share a brief timeline. So of course, the Voting Rights Act passed in 1965. There were beyond that many authorizations which reauthorized. I don't know if folks know, but the Voting Rights Act required that every 25 years that the right for Black folks in this country to continue their right to vote and that be protected was reauthorized every 25 years or so. And so there was reauthorizations in 1972, 1982, 2006, and such. And so the League really got involved in the voting rights fight in the early 70s. and we've continued since then. And so that's why the 1972 placeholder is there. And then we moved to 2013 because we were just kind of chugging along. The Voting Rights Act passed, everybody was doing this work, and the fight was hard, but it was still moving. And then the Shelby v. Holder decision, Shelby County v. Holder decision happened, which really gutted important provisions of the Voting Rights Act, including Section 5 and Section 4, the pre-clearance portions, which basically if a state had a history of, or not even states, some localities who had a history of bad behavior or around voting rights, they had to get pre-clearance or permission to make changes to voting laws. And then the other piece of the Voting Rights Act that was eliminated was the part that identified which jurisdictions were subject to it. And so that was a huge loss. We've seen since that time just a slew of voter suppression bills and laws that have come into play, including voter ID and restricting people's access and participation. And so in 2018, we had the Russo case, which was a redistricting case out of North Carolina that was also combined with a case out of Maryland. And this was challenging when redistricting goes bad. Essentially, the league was involved in this case, and we thought it would be the perfect case because we had the Democrats doing bad things in one state and the Republicans in another state. So we thought that we were positioning this case perfectly for the court to decide when gerrymandering goes too far, but they did not. They declined and said that this is not part of federal jurisdiction anymore, and that this is going to now be with states. And so that decision was really monumental and led to us starting our people-powered Fair Maps initiative as a result of that decision. Next slide, please. So the impact of Shelby County v. Holder, it increased strict voter ID laws across the country. There was a mass consolidation of polling locations during election cycles, many times in the South, but I know that this also happened in Ohio, Michigan, Wisconsin, so in this neck of the woods as well. There were cuts to early voting, both hours and the days that people had access to the vote, and aggressive voter purges. You know, in Ohio, we saw what happened with an aggressive voter purge in the Houston case, which was successful in purging, many people. Next slide, please. And then I want to talk about why this matters now. So currently in Congress, or in Congress, there's a bill to restore many parts of the Voting Rights Act that were gutted through the Shelby County v. Holder decision. And so it's a really important bill. The league has endorsed this and has been supportive since it was first introduced several years ago by the good House representative in Alabama, the very county where this happened. And so I want to talk a little bit about the Voting Rights Advancement Act. It's now been renamed the John Lewis Voting Rights Advancement Act, and what it would do. And so the first thing it does is it implements a new coverage formula with modernized discriminatory factors. And so when we talked a little bit about what was gutted in the Voting Rights Act, part of it was who's subject to it. And so this would implement a new coverage formula that won't go back to 1965. It'll go back just 25 years to figure out what discriminatory behavior is now subject. It also establishes new pre-clearance criteria have to do if they have a history of voting discrimination. It improves transparency by requiring reasonable public notice for voting changes. One of the problems with voting changes is the public sometimes doesn't know what's happening. There's little requirement to let the public know that these changes are happening. It just kind of shows up in law sometimes. And then it also permits the AG, Attorney General authority, to request federal observers in response to serious threats to racial discrimination. We saw in the last administration that the DOJ kind of took a back seat to some of the voting rights cases and claims that arose. This would mandate that there's a larger DOJ presence in these type of situations. And finally, it enhances accessibility and protections for Native Americans and Alaskan Native voters. There's also a Native Americans Voting Rights Act, but it was very important to make sure that understanding that not only Black folks, brown folks being affected, it was important to include Native Americans and Alaskan Native voters in this coverage as well. Next slide, please. And so I'll just close really quickly by just talking about the relationship between VRA and MAPS. I tried to keep it really simple. So the Voting Rights Act Section 2 and 5, the two we talked about, it's been used in countless redistricting cases to challenge, and additional election cases as well, to challenge unfair maps, but also electoral barriers to the ballot. And the second is in 2021, this will be the first time since 1965 that the VRA will not be in place for a redistricting cycle. That is critical because it means that certain people in this country, particularly Black and Brown folks, but also income sensitive folks, et cetera, will not have a remedy in many ways for pushing back when voting rights are restricted or limited in some way. And then finally, the VRA provides the best opportunity for communities of color to challenge maps when things don't go well. And so I think it's critical that we, with the delay of the census data and things like that, we now have time to try to pass a VRA that can be in place for the upcoming redistricting cycle, or once there are challenges that come from those maps that are drawn. So thank you so much. Hopefully that was helpful context for folks, and I will turn it back over to Brandi. Thank you so much.
Thank you. Gosh, I'm chomping at the bit for questions, but I have to have some type of restraint here. We will give an opportunity for questions towards the end. So if you, like me, are thinking those through, type them in the chat. We're following and recording them, and we'll certainly get back to them in just a few moments. It is my honor to also introduce another speaker. Today we have with us Dr. Handley, and Dr. Handley has been involved in the electoral assistance in more than a dozen countries, serving as a consultant on issues of democratic governance, including voting rights, electoral system design, electoral boundary delineation, and electoral dispute resolution for the United Nations, the United Nations Development Fund, the International Foundation for Election Systems, and International IDEA. In the last couple of years, she has participated in elections missions in Afghanistan, the Democratic Republic of Congo, Georgia. Gosh, isn't that something that we have to mention Georgia alongside other countries when we're talking about elections? Liberia, Nigeria, Sierra Leone, Sudan. In the United States, Dr. Handley's clients have included the U.S. Department of Justice, numerous civil rights organizations, and scores of state and local jurisdiction. In addition, she has served as an expert in dozens of voting rights court cases. Dr. Handley has been actively involved in research, writing, and teaching on the subjects of democracy building and election administration generally, and on voting rights and boundary delineation more specifically. She is the president of Frontier International Consulting, an election consulting firm that specializes in voting rights and electoral boundary delineation. She holds a PhD in political science from George Washington University. Welcome, Dr. Handley.
Thank you very much, Brandi. I need to apologize. We've got a windstorm here, and I am not sure if I put on the video, if I'm going to keep this internet connection. So we're just going to look at my PowerPoint, if you don't mind. Anyway, it's a pleasure to be here. What I want to talk about is how a social scientist helps in determining how, if a redistricting plan complies with the Voting Rights Act and with the 14th Amendment. So I'm not a lawyer, I'm a political scientist. And let's go to the first slide. Okay. The Voting Rights Act prohibits any voting practice or procedure, including a redistricting plan or an electoral system such as an at-large system, that results in the denial or the dilution of minority voting strength. What does this mean in the context of redistricting? It means that a redistricting plan cannot crack, pack, or submerge a geographically concentrated, politically cohesive minority community, at least not if white voters consistently vote against minority preferred candidates, and these candidates usually lose. Next slide. So how do we know if minority voters are politically cohesive? And how do we know if white voters usually vote to defeat the candidates preferred by minority voters? These two conditions constitute the second and third prongs of the Jingles three-pronged test. It's a set of preconditions that were prescribed by the Supreme Court in a case called Thornburg v. Jingles to determine if a redistricting plan violates the Voting Rights Act. If both of these conditions are met, then voting is said to be racially polarized. If, in addition, a majority-minority district can be created, this is the first prong of Jingles, then at least one district that provides minority voters with an opportunity to elect their candidates of choice must be drawn. Given that we have a secret ballot in the United States, how do we know who minority and white voters are supporting when they go to the polls? Well, this is where political scientists and social scientists come in. We use statistical techniques to produce estimates of voting patterns by race. Next slide, please. So two standard techniques used to conduct a racial Black voting analysis are referred to as ecological regression and ecological inference. I'm not going to describe those to you. I'm just going to show you what the results look like. So in this, the example in this table reports the results of an analysis of the 2008 Democratic primary in a county in Ohio, I think it is. In this election, voting is polarized. You can see that Black voters are cohesive in their support of Obama, according to the estimates produced both by ecological regression, that's the ER column, and by ecological inference, EI. White voters, on the other hand, preferred Clinton, who carried this particular county. If this pattern of polarization is repeated again and again across many elections, either primary or general elections, and the Black preferred candidates usually lose, districts that provide minority voters with an opportunity to elect their candidates of choice have to be created in that particular area of the state. This analysis of voting patterns is important for another reason. Knowing the relative participation rates of minority and white voters and how much white crossover votes minority preferred candidates generally receive in a specific area of the state assists in determining how to draw minority districts that provide minority voters with an opportunity to elect their candidates of choice. 50% minority in a district is not a magic number. For example, if Blacks and whites turn out at comparable rates, and there's a consistent amount of white crossover votes, say around 30% for Black preferred candidates, it may be the case that a district with less than 50% Black, perhaps as low as 40% Black, provides Black voters with an opportunity to elect their candidates of choice. On the other hand, if Black voters turn out at a much lower rate than white voters, and there is virtually no white crossover voting, it may be the case that a district with a Black population as high as 60% is needed to provide Black voters with an opportunity to elect their candidates of choice in that specific area of the state. Next slide. The US Supreme Court, beginning with the 1993 case Shaw v. Reno, declared that the excessive and unjustified use of race in redistricting violated the Equal Protection Clause of the 14th Amendment to the US Constitution. If race appears to be the predominant factor considered in district drawing, that is, if districts appear to be racially gerrymandered, a redistricting plan will be subjected to what's called strict scrutiny by the court to determine if it has been narrowly tailored to serve a compelling state interest. Compliance with the Voting Rights Act is a compelling state interest, but what what do we mean by narrowly tailored? A district-specific functional analysis is required to determine if minority districts have been drawn as required by the Voting Rights Act, and if they've been drawn in a manner that provides minority voters with an opportunity to elect their candidates of choice without unnecessarily packing them. This means that an arbitrary target of, say, 50 or 55% minority cannot simply be applied statewide to all minority districts. Instead, an area-specific determination must be made based on voting patterns in that area specifically. Next slide. I want to provide an example of balancing compliance with the Voting Rights Act with the requirements of the U.S. Constitution here in Ohio. I was involved in a partisan gerrymandering suit challenging the 2010 Ohio Congressional Redistricting Plan. My role focused on the 11th Congressional District and whether it was narrowly tailored to comply with the Voting Rights Act. Next slide. On the basis of my district-specific functional analysis, I concluded that the strangely shaped congressional district that for the first time extended down below Cuyahoga County into Summit County to produce a 52.4% Black district was not, in fact, narrowly tailored. A more compact district, fully contained within Cuyahoga County, but with a lower Black voting age percentage, would certainly have provided Black voters with an opportunity to elect their candidates to Congress. So what this means for the upcoming round of redistricting is that a district-specific functional analysis must be conducted to ensure that minority districts required by the Voting Rights Act are drawn so that they provide minority voters with an opportunity to elect their candidates of choice without unnecessarily packing the district or unnecessarily violating such traditional redistricting criteria as compactness and keeping political subdivisions intact. Let me add one caveat before I end, and that is that none of this is to say that you cannot or should not draw districts with substantial minority populations if they are a geographically concentrated community of interest. You can certainly do this so long as race is not the predominant factor in the creation of these districts. And that concludes what I have to say today.
Thank you so much, Dr. Handley. Again, packing, cracking, all these things that diminish the voice of the people. I'm so excited to dig in on this a little bit deeper. I want to introduce our final panelist, and that is Miss Alora Thomas-Lomborg. She is a senior staff attorney in ACLU's Voting Rights Project. As part of her work, she has litigated voter modernization, voter suppression, and partisan gerrymandering cases. She has also co-authored several amicus briefs before the Supreme Court on partisan gerrymandering. She was one of the lead attorneys in the ACLU's Ohio partisan gerrymandering case, Householder et al. V. Ohio A. Philip Randolph Institute et al. Prior to joining the ACLU, she was a litigator at Wilmer, Hale and Simpson, Thatcher, and a clerk for Judge Brody in the Eastern District of New York. Ms. Thomas has her BA in political science from Yale University and her Juris Doctor from Columbia Law School. I do want to, before Laura starts, she has this beautiful Miss Ella that joins us from time to time. So if you see the 3-year-old brilliant person of that household, that's who it is, Miss Ella. Alora, please take us forward.
Great, thank you. I'm so happy to be here. And the pressure is on because both Celina and Dr. Handley were at 10 minutes. And I make no promises. I did promise Jen I was gonna be at 10 minutes, but lawyers, sometimes we like to talk. So I'm gonna try my best. So if you all just bear with me for a second. The other apologies I have to make at the top is I have a bit of hay fever, so I might sneeze or cough again. Apologies. I'm not taking medication for it right now, and so it's a little haywire. I like to start talking a little bit about kind of my background and how I came to voting rights, because I think it helps center some of this next phase of discussion. So I come from a family where my mother went through desegregation in South Carolina. And I grew up with stories about what it was like for her to desegregate her school, including the death threats to her home and the parents protesting outside of her school and the kinds of harassment that she received inside of her school. And that made me really kind of interested growing up. My whole life, I've been interested in the civil rights movement. And when you study the civil rights movement, you see that voting rights is really at the center of the civil rights movement. And as Celina wonderfully led us through, with the culmination of the Voting Rights Act in 1965. And that's for a lot of reasons you can think about, including that you can't really, a lot of the systems that were keeping people oppressed were not just de facto, they were in fact by law. And so the only way that you can change those systems is actually having a seat at the table and influencing what those laws are. That's not to say that voting is the only way in which these changes can come about, but it's a centerpiece and it's a really important piece of that. And that is what the Voting Rights Act was trying to accomplish and establish, is to make sure that folks who had not had a seat at the table for hundreds of years were finally given an ability to have a say in the political process. And so I always come to this work, even though I do a lot of different, as was said in my intro, a lot of different parts of the voting work. It's always been centered for me on this idea of racial justice and equal participation. And for a long time, I think there's been this idea that that goal is at ends with other goals that we may have, for example, partisan fairness. And I think our case and the way in which this coalition approaches the work shows that that is not the case, that you can achieve dual goals, and that's always been really important to us. So I will start now with my presentation. So I don't have a really pretty cover page, which is partly why we're starting from the beginning. And I just wanted to take a step back, something that I learned from my boss, and define a few of the key terms that we've been talking about. Celina and Dr. Handley touched on some of these, so I won't spend too much time, but I do think it's helpful as we move through the discussion. So the first one is vote denial. Both vote denial and vote dilution, which is the second term, are part of the Voting Rights Act, but they're different. So vote denial, I think, is the one that folks may be the most familiar with. And that's the kinds of things like voter ID laws, voter purges. Vote denial is what prevents voters from getting to the ballot box, either through registration or other tactics. And it gets a lot of attention. And I think the link between vote denial and racial justice is understood kind of wildly out there, but not as much vote dilution, which is what we've been spending some time talking about today. And vote dilution says that it's great if you can get to the ballot box, you can vote, but if your vote doesn't have any power, because as we said, you've been cracked and packed into various districts, that's still a problem. And so both vote dilution and vote denial are part of the Voting Rights Act. We still can bring cases under Section 2, but one of the problems with bringing a Section 2 case and why we miss Section 5 is Section 2 cases are brought after the fact. So something bad happens, and then we go to court. Where prior to Shelby, we were able, at least the Department of Justice was going in and looking at plans, looking at laws before they ever went into effect and deciding what the racial implications of those were. The other term that, again, I think Dr. Handley really touched on is this idea of racial gerrymandering. So one thing to know about vote dilution is, and I'm going to get into it, there's a test for vote dilution, but vote dilution under the Voting Rights Act, intent is not an explicit component of the test. We argue that a lot of the components of the test get to intent, but the racial gerrymandering case, which is brought under the 14th Amendment, is saying that race was at the heart of what the redistricting plan was about. That was your intent, and that is outlawed. In addition to racial gerrymandering, there's also partisan gerrymandering. So racial gerrymandering is cracking and packing along racial lines, where partisan gerrymandering is cracking and packing along political party lines. Next slide, please. And so vote dilution is protected under Section 2 of the Voting Rights Act. Luckily, it's something that we still have. And as has been said previously, the goal is for minority communities to be able to elect their candidate of choice. And you have to look and see who the candidate of choice may be. I think Dr. Handley gave us a great example of in the 2008 primary, Obama was often the candidate of choice of African-American voters. But if you look at the most recent primary, we saw that Biden, in fact, was the candidate of choice in many states, even when there were two strong Black candidates in the field. So candidate of choice may or may not reflect the race of the voter, which is why race has been used as a shorthand of trying to figure out if the candidate of choice in an election, in fact, won, but you have to do more than that. And you have to look at the voting patterns and really hire someone like Dr. Handley to tell you in various elections who the candidate of choice is. So that's the goal. And again, I'm not going to spend too much time on the preconditions because Dr. Handley did, but there are 3 preconditions for determining if a district should be drawn to meet Section 2. One is it compact, meaning are there enough minority citizens living together that you could draw a majority district? Even if ultimately the district you draw is not majority, compactness has been defined in Strickland as can you draw a majority district? And then there is the questions of is there political cohesion in the minority group, and does the majority vote in a block? And Dr. Handley discussed that, so I'm just going to move on. In addition to those preconditions, as litigators, we have a whole other set of factors that we need to address when bringing a Section 2 case. There is, sorry, I'm just going to wait till we catch up. Okay, I will just go and hopefully we're going to catch up with the PowerPoint. So as litigators, there is a host of other factors that we have to look at. There isn't a set number of these factors that we have to check the box, but the goal is to look at as many of these factors as possible in bringing a Section 2 case. So is there history of official discrimination, whether there's socioeconomic discrimination in the locality, are there racial appeals in campaigns, which I think for a long time you didn't see in a lot of places, but thanks to the most recent presidency and some of the rhetoric that has come since the most recent election, I actually think we're seeing more and more racial appeals in campaigns than ever before. the extent to which minority candidates have won, whether or not elected officials are responsive to minority concerns within the jurisdiction, and then whether or not the justification for why district has been previously drawn in a certain way, it was tenuous, really kind of like the BS factor. Does their decision making actually make sense? If we could move to the next slide. So does Ohio have Section 2 districts? Another thing I just want to highlight here, I'm just looking at 3 parts of Ohio government. Section 2 goes to more than these 3. So it goes to school districts and other smaller districts. But just to kind of ground us, to answer the question, are there any in Ohio? Yes, there are. So there is the 11th district in Congress, and then there are a number of districts in the Ohio House, Senate, and House. Now, I would like to give a big caveat in that we have not yet we have not yet done the kind of analysis that Lisa does. So this is my looking at the kind of rough numbers. Where does it look like you could potentially meet the Section 2 factors? And that is not to say that this list is exhaustive or exclusive, but these are the places when I look at Ohio data and I see that there seem to be enough people living in community that a Section 2 district can potentially be drawn and validated there. And no surprises, you see Cuyahoga County, you see Hamilton, you see Franklin counties. Next slide, please. So getting to how do we get partisan gerrymandering and racial gerrymandering together, we brought a partisan gerrymandering case back in 2018 because of the really stark numbers that we saw in Ohio. You all live there. So I know this is not a surprise to you that even when the vote shares of Democrats changed, the seat share never changed, telling us that there was a problem of cracking and packing of Democrats. Now, because we and the coalition approached this problem in a holistic sense, we wanted to be sure that we were thinking about racial justice at the same time that we were pursuing a partisan gerrymandering case. Let me just go to the next slide. And again, why did we bring it? Well, we were hearing from folks on the ground that they felt like their vote didn't count. People were confused about their congressional districts, and you saw a kind of lack of participation. And a lack of participation, whether it's for racial gerrymandering or partisan gerrymandering, it hurts everyone. The system works best when everyone is engaged and everyone participates. If we could go to the next slide. And this feeling out there that it doesn't matter what we do, the outcome of the election isn't going to change, was borne out in the kind of analysis that we did in the case, which we saw that it wasn't until Democrats won the majority of the seats that they would actually get an additional seat in Ohio's congressional delegation. And even then, they would still only have a minority of the seats. So the feelings of, I'm not sure if my vote counts, in some ways, it was justified by how hard it has been to really change the outcomes of the representatives being sent to DC. Next slide, please. And so the goal was to change the map and make it something that was responsive to voters and to all voters, and that was cognizant of the racial justice implications. So we hired Lisa, and we wanted to make sure that we were taking a particular care with District 11, and that we weren't creating a district in which could not elect a Black representative. We wanted to make sure that that district was intact. And we also wanted to test this theory that we were told by the defendants that that certain areas of the map were drawn because racial justice required that. And so we wanted to look and see, well, is that true? Could you get a map that is both racially just and just on a partisan basis? So if we could go to the next slide. So I'm about to round up. Lisa already talked about District 11. We were able to, with Lisa's analysis, redraw District 11 in a way that would keep Cuyahoga intact and continue to elect a representative of choice. And that just makes more sense. So you're not cracking and packing the Democrats down in Akron to try to gerrymander the map. If we could go to the next slide. Same thing for District 3 in Columbus. This is what we would typically call an opportunity district, where you see enough African Americans living in Columbus that they can influence the election, but they're not over the 50% threshold. We were able to redraw District 3 at the exact same African American citizen age population and not crack and pack communities in the kinds of crazy ways that had been done before. And then if we could go to the next slide. And then another place, the last one I'm going to show, is we looked at the Hamilton County district. And here we've actually improved the number of African Americans living in the district while making it less crazy and not cracking and packing Democrats. So we went from a 26, we actually increased African American representation in the district by 5.5 percentage points. And with that, I will end.
Thank you so much for that, Alora. It's time. It's time. We're going to open the floor to questions, and I have a few that we've pulled from the chat. Let me see what we have in front of us. Our first question, and it's related, Alora, to what you were just kind of sharing. What if we can't create minority majority districts? What are our options?
Sure. So I think it was really helpful for Celina to talk about litigation is the last step. So we might not be able to create majority minority districts, which is what you would need to go and litigate a case. That does not mean that outside of litigation, we shouldn't be thinking about opportunity districts and whether or not we're keeping communities intact and creating districts where communities can influence the process and participate in a district that makes sense. So we spent some time talking about District 3 and District 1. Those are not majority minority districts. That doesn't mean that gives a map drawer carte blanche to go into these communities and crack and pack them, or that folks who are working on maps shouldn't be thinking about where are the communities of interest, are we keeping them together, even if it's not going to turn into a VRA suit down the line, or yeah.
Yeah, you know, this is why it's so important that we engage in some of this community map making, because we understand our communities where a map maker may not. You know, they're looking at it from a different frame. And so thank you for your answer, Alora. I don't know, does Celina, do you want to respond to the same question? And we do have a few. What if we can't create majority districts? What are our options?
Yes, I don't have much to add to what Alora lifted up, because I think it's so important. But it really comes down to how the district is drawn. And I know we talked about cracking and packing. Hopefully that's clear for people. But with packing, it means that perhaps Black people have come together with Latinx community as well, and only need 40% of the vote in order to elect their candidate of choice. But this district has put 68% of people of color. We don't need all that. That's probably not the most professional way to say it, but it concentrates the power so much that in that one district that it penalizes or limits, handicaps Black folks in other parts of the state. And so I think that it's so important for people to be engaging in redistricting as early as possible. When maps are drawn, sometimes that's, too late. We can push back. Litigation is an option, but again, it's expensive and cumbersome and takes a lot of time often. And so being on the record with what your community looks like is so important. Who is my community? Why are we bonded by something, whether that is all of our kids go to this school, or we share this resource, or we all depend on this particular thing in this county and come together to do these things. That's so important, not only as we lead up to redistricting, but also if you need to create a record about how people were perhaps ignored.
Yeah, I wonder if any panelists, I'm not sure who's best to respond, but the question is about the census, the 2020 census, and whether or not we think minorities will be undercounted, and if so, what are our options as it relates to the census? Anybody?
I mean, that's a scary question. Laura, you gonna take that?
I think it's just too early to tell, right? I mean, we won't know until the census comes out. To be honest, I'm less concerned about Ohio than some of the smaller rural communities, and especially if you think about like Native American communities, harder to reach communities. But we're hopeful because they have ways to go in and clean the data, and they're taking this extra time to try to make sure that what we're getting is accurate. And until the product is released, we have to kind of let it work its way through and hope for the best, quite honestly, is all we can do at this point.
And the only thing I'll add is I know that some data is going to start coming out, between now or the reapportionment data is going to start to come out between now and next Friday. But that will be I think that will be a really good indicator, because we'll know if states lost seats, if they picked up seats. So we'll know how population is somewhat trending, even if we don't have like final numbers for redistricting. But that's going to be really important, because it also lends to what the political power in that state is going to be and how people are going to have to show up in elections for the next decade. And so I think it is going to matter. I totally agree with Alora. It's kind of a wait and see type thing, but we will start to have some information, I think, in the next few weeks to give us an idea of what redistricting might look like in September when states start to get that fuller data.
Yeah, so while we're on the census questions, one of the questions from the audience was, if we are unable to meet legal deadlines in Ohio due to the census delays, how might that impact VRA challenges?
So I think they're two separate questions. If Ohio cannot meet the deadline, there isn't a federal problem. Okay, federal law does not adhere to the same timeline that is in Ohio's constitution. If Ohio decides to redistrict based on old census data or some other census or some other data that's not the 2020 census, then there's a potential apportionment problem, which is a separate voting rights claim based on, you have to, especially for Congress, draw the district of kind of equal population, and you have to know what the population of those districts are. And we know that in a 10-year period, there are population shifts and people move. So there is that potential legal problem if the 2020 census data is not used to draw districts. But that is kind of a separate problem than VRA, because that comes under the 14th Amendment.
All right, perfect. There's a question, can the speakers talk about whether Jim Jordan's duck-shaped district violates the Voting Rights Act?
So that's not a VRA violation, because it's bordering the kind of Franklin County sinkhole. We argued that all of Ohio's districts are a partisan gerrymandering violation. I think folks know, and I didn't want to spend too much time in my presentation talking about this, but the outcome of the Supreme Court case was that we can't bring these cases to federal court. There's still the option of bringing these types of cases to state court, which I know is something that a lot of folks are interested in and thinking about, but that would be a partisan gerrymandering violation and not a kind of racial cracking and packing.
Awesome. So there's this question. Do districts that are drawn to comply with VRA issues impact any Ohio districts outside of Franklin, Cuyahoga, and Hamilton counties? Just specifically, where does it matter in Ohio?
So I think, and we haven't done the analysis, but I think if you look just at the numbers, there is potentially in Ohio's House, you should be looking at Lucas and Summit counties also, and probably at lower levels of districts, so like school districts and other districts, you may even be looking beyond that. And by Ohio House, I mean the Ohio General Assembly, not US Congress.
You know, I'm looking, we've got questions and questions, and I'm trying to pull out, you know, some really good ones here. They're all really good, but something that will have some dialogue across our panelists. So, you know, maybe just your reflections on this. As Michelle Alexander says, the government gets around passing racist laws by changing a few words so that race isn't specifically mentioned. Is this how they get away with these ridiculous districts? Maybe speak to how we even get to this point where there's cracking and packing and diminished voice in our communities. Dr. Handley, let's start with you, as we haven't heard from you here in the last couple of questions.
I don't know if this is going to work. The wind is dying down. We'll see. I think the story begins when Black voters actually got the right to vote in the South. Prior to that, you had districts that were heavily Black in the South, like in Mississippi in the Delta area. And it wasn't until the Voting Rights Act passed in 1965 and the districts were redrawn specifically so there wouldn't be any majority Black districts that we got involved in what does race mean in the context of redistricting. And it was because the minority population was cracked in many Southern congressional districts and state legislative districts that we first stepped into this area. And I think I'll stop there because I can't remember exactly what the question was.
The question was just, how were these ridiculous districts even drawn? I think the tension is, part of the packing is to ensure minorities are represented in, there's this fear that if you make the districts more competitive, will people of color still be able to represent folks in seats in the Ohio General Assembly, Congress, or where have you. So I think the question is, one, how does this even happen? And then two, how do you balance the tension? How is it that by changing these districts, will people of color still be competitive and still be, will I still see a Congresswoman Beatty, an African-American female, someone who represents me and my interests and lived in my community? Any thoughts about that to any of the panelists at this point?
I do. I mean, I hope that the 2020 election was a reckoning for many people across the country that when people turn out, outcomes can change, even outcomes that you think aren't possible, right? We saw that across the country. We saw it in Georgia specifically. I know that we often talk about that. But I do think, to your original question, that language does matter. In many of the voter suppression bills that we see coming down the pipeline across the country, it is often neutral language. But I think what we have to look at is, beyond the neutral language, what is the impact that will have? And I think when you focus on not only the words of the legislation, but the impact it will have, it becomes much more clear what intent is and who's being targeted with particular bills. And I don't think we can ignore that. I think that we have to look beyond the words, because everyone is really clever right now in how we write stuff. We can spin anything in today's, world. But I think we have to focus on impact. And some of the voter suppression bills and laws that are happening across the country, regardless of what they say, have a very direct impact on Black and brown voters, poor voters, women voters. And so when you are looking at such a strategic and surgical impact on certain communities, I think that it goes beyond words and can often show what the impact actually is. But it's harder.
Yeah, and I'll just add that Section 2 explicitly does not include intent. In fact, the Supreme Court said, we think it includes intent, and Congress went back and said, no, we said it's a disparate impact standard. Now, it's really disparate impact plus, because you're looking at whether, so just taking the districts, can you draw a majority Black district? Is there indications that voting is racially polarized there? And it's not just majority Black. I mean, obviously in other parts of the country, we were talking about majority Latino, majority Native American, majority Asian. It applies to all racial and linguistic minorities. So can you draw these districts? And then we have all those Senate factors that I went through, which we often argue is a kind of is a backdoor way of getting to intent. So you're not having to go into the legislative record and say, they said they were doing this to hurt Black people. That's not required by the VRA. As far as the other part of the question about whether doing the kind of partisan work harms the racial justice work, that was explicitly what we were concerned about as a team, which is why you got to hire someone like Dr. Handley to do the analysis for all the districts. And it will, as she said, it will differ. Like in a place like Cuyahoga, you can elect a candidate of choice at less than 50%, but you can't do that in certain places in the South because the turnout rates aren't high enough, and you really have to be like in the high 50s, low 60s in order for a candidate of choice to be elected. And all that has to be taken into consideration, which is why folks have to be thoughtful. And that's what we said the state wasn't doing. Be thoughtful about each locality and like what is required for that specific place. And it's going to differ depending on where the place is.
We're getting close to time. We've just got, I'm going to do maybe a couple more questions and then turn it over to Jen to close us out of our session. I mean, this is, my mind is swimming because you guys are so, the depth of knowledge that all of the panelists have on this subject matter, and trying to transfer that in a way that local communities understand the urgency of this is really what, you know, my mind is turning around at the moment. A question here that we have is, what would prevent the majority party in the Ohio legislature for not adhering to the process and simply approving their own plan?
Threat of being sued.
Okay.
That's a Jen question.
Jen,
What is that question?
we'll come back to it, Jan. We'll come back to it. Let's see. I'm just trying to make sure that I get everyone's, you know, comments here or questions here. Oh my goodness, I'm sorry. Give 1 second here. I think I saw one that I really, the question is, I live in a district that has been historically a minority majority district. Is this currently legally required, or has that requirement been repealed?
So if you're in, and I don't know at what level we're talking about, but if you're in a district that is performing a majority minority, your district should continue to be able to elect a candidate of choice. Whether, I don't know, again, because I don't know what this district is, I don't know if the level that your district is at, it needs to be. Like we found in Cuyahoga, Dr. Handley found that the level of the new District 11 was not required for them to continue to send a African-American representative to Congress. So that may change, but if your district is currently performing, it is required that it continue to perform for your community, if that makes sense.
Perfect. And then the final question, because this was a point of clarification, this is directed to you, Celina. When you said that the VRA is not in effect, do you mean that you meant specifically Section 5? Could you just offer clarification?
Yeah, well, what I was saying is that because as a result of Shelby County v. Holder, sections were gutted, which made the VRA have less teeth than it had before, and being able to be used effectively. And so litigators like Alora, self, and many litigators across the country have to be very creative now in how you bring these lawsuits. And so yes, the VRA does still exist for all intents and purposes, but it certainly does not have the teeth that it had prior to 2013.
Perfect. Well, I want to just say thank you so much to this fabulous panel. I want to be like all of you when I grow up. That is the honest to God's truth. But what you've provided for us today, you know, is a depth of learning that I really think our audience appreciates and enjoys. Jen, I want to turn it over to you because I'm sure folks are out here like, we've heard all this. Now, what can we do? Jen, tell us what we can do. I take all of my marching instructions from Jen. So please tell us what we should be doing next and how we can ensure our maps are fair. You know, we want the people to have power. So instruct us, Jen.
It's impressive that Ella didn't make it, but Monster Kitty did. And Monster did like at one point mute my computer. So if you guys were saying something to me, I'm sorry. I would love to give like just 15 seconds to each of you, including you, Brandi. If there's one thing that someone walked away with today, what is it? So let's start with Dr. Handley.
In my mind, it's let's start the analysis. Let's figure out what we need in specific areas of the country before we start drawing districts, because in my mind, the thing that we want to make sure that we do is comply with the Voting Rights Act. If you bring it to suit, you have to be able to draw a majority minority district to win the suit because of the first prong of jingles. But if you're drawing now, or you're creating a remedy, it doesn't have to be 50%. So let's do this analysis now and figure it out.
That's great. Celina?
I think on the grassroots level, get involved. It is so important for people to be engaged now about like if they're doing community mapping in your area, to plug into the league or other organizations on the ground doing this work so that you can be plugged in. Because I think public testimony is going to be critical here. And so I think the only way we can do that is if we're plugged in. So please, please, please just make sure you're getting plugged into redistricting locally now.
Alora?
I think mine is just that racial justice and partisan fairness are not at odds. I think we've been sold this story by a lot of people who have done it for their own motive. And it is important, though, that we have to be thoughtful about each, because if you're just working on one and not thinking about the other, they then can harm each other. But if you're being thoughtful and intentional and thinking about both aspects, I think that's when you get the best maps.
Brandi?
Yeah, I love all of those comments. I think my point is that this is so important. And we shouldn't allow, oh my gosh, we shouldn't allow the partisanship of some of this, the fact that our maps have been drawn in bunkers, you know, all of the things that are negative about this work keep us from jumping head in and working hard to make sure that we have fair maps that are representative of us. I have worked lobbying, advocating with the state legislature and Congress in Ohio, and it's just time to turn away from these super majorities and get a map and get representation that reflects all of the values across Ohio. So those would be my final thoughts, Jen. We can do it. Let's do it. Let's get active and engaged and, you know, bring forth a change because these maps impact so many other policies that impact our lives.
Well, thank you. I just want everyone to know that these four incredible women have taught me so much and continue to inspire me so much. And so I'm glad that you all get to kind of experience what I get to experience, which is I get to pick these brilliant brains about what we need to do. And so the first thing is, this is our first conversation. This is not the last when it comes to something like the Voting Rights Act. If there's one thing I want everyone to take away, it's that racism is upheld and reinforced by laws. And so who is elected to make those laws matters as we're trying to make a more equitable society. And so, and I agree with Alora wholeheartedly that we can make maps that are racially fair and fair in terms of partisanship. And so what can you do? We're gonna one time, again, Catherine has put something in the slide there on what you can do. You can contact your lawmakers. One of the things that needs to happen right now is what Dr. Handley said. we need to start talking now. Let's not wait for the decennial census data to talk about things like the VRA, to start doing certain kinds of analysis or discussing how we can serve the needs of every Ohioan in the map making process. So we do need to start that now. We have people trained to do community mapping with you today, and we have people trained to do Speakers Bureau. Ask those folks, ask fair districts. We're the nonpartisan experts in fair districts. Ask us to come to your community, to speak to your community about redistricting or to make a community map. Become a member of League. If we end up having to sue, which of course we don't want to, it's helpful the more members we have, and it's also helpful as we go and talk to lawmakers. And then finally, donate. We are going to be having all kinds of things. We're going to flood the state with signs, right? Fair district signs. We're going to make sure that, you know, schools across the state are hearing about map making. We're going to make sure that we continue to have programs like this so you can all get engaged. So also make sure you donate. And with that, I just want to say it is my absolute privilege and honor to be with all of you tonight. And I hope that you have a wonderful evening. So thank you, everyone. Oh, and shout out to Pooja. Pooja Chowdhury is here too. So another rock star civil rights lawyer in the house, as well as Ann Hankener, whose shoulders we all stand upon as a fair districts guru. So thank you so much, everyone.